Hi, everybody. I wanted to make a video going through the initiative text for IP28 in quite a bit of detail. I actually want to go through each section and explain how this initiative works. This video is primarily intended for new petitioners on the team so that you can be really confident when talking to the public, but I'm also going to make this video available publicly so that anyone who is hearing about the initiative and wanting to know more can have this walkthrough. So to start, it's probably helpful to know that IP28 stands for Initiative Petition 28. That number is simply meaning that we were the 28th proposed ballot measure for the 2026 election cycle. We submitted it on October 16th, 2023. You can see the timestamp of when it was received up at the top right. And the actual name of the proposed measure itself is the People for the Elimination of Animal Cruelty Exemptions Act, so the PEACE Act. So the PEACE Act is technically the official name for it, but most people just know of it through IP28. In Oregon, it's pretty common for people to talk about initiative petition numbers until we get a measure number, if and when we qualify for the ballot. We start off the initiative with a resolution, very simple resolution statement, that actually acknowledges Oregon being a state that recognizes in state law that animals are sentient beings capable of experiencing pain, stress, and fear. It's pretty uncommon for states to recognize this in their animal cruelty statutes. And although we do, we go on to then justify, to legally exempt a lot of cases where we inflict pain, stress, and fear on animals. So it doesn't, in my view, really help that we have this acknowledgement, but I wanted to point it out so we can really sort of say, hey, look, we accept that they are sentient, therefore, we propose removing the exemptions that currently exist that we think are unnecessary, so in order to reduce the suffering of animals and improve their quality of life. In particular, these current exemptions are to laws governing animal abuse, animal neglect, and animal sexual assault. Those are our three of our big key animal cruelty statutes. And we're going to go over each of those individually. But before we do that, the first section following the resolution is a short policy section, reiterating that our intention is to reduce what we consider unnecessary harm, what we consider inhumane harm. And most importantly in this section is actually this last provision that says, 1, the act shall be interpreted consistently with the purpose that we just stated, and it shall not be limited by any policy set forth in Oregon law that could conflict with or be interpreted to conflict with the purposes and policy objectives stated in the section. So I think there's already a convention that when a new law comes into effect, it would supersede prior laws. This sort of just makes that explicitly clear. Right. So almost the rest of the initiative, or at least the main impact of the initiative, has to do with amending Oregon revised statutes, okay, and a series of them that have to do with our animal cruelty statutes. So it's under the section removing exemptions. I'm actually going to jump to a different section first. We'll come back to section 2 because I think it's helpful for people to understand this in a particular order. And the order that they're in the initiative is just chronological in state law. It's not necessarily thematic. And so I think it actually helps to jump around a little bit. So we're going to go instead to section 3. And before we start, an important note for reading how to read these initiatives. Any text that is in bold, okay, bold font, is something that would be added to the initiative or to state law if this initiative were to pass. Anything that's both in italics and brackets would be removed from state law, but it's currently there. Okay, it's currently there, but would be removed if this were to pass. Any other text, at least in these sections here, where it says this section is to amend, right? any regular text in these sections is already in state law. So we are not adding this. This is already how the state law looks. Okay, so we are making amendments to it. ORS stands for the Oregon Revised Statutes. This is our, statutory laws. Chapter 167 includes our animal cruelty statutes, and these list specifically the specific statutes. So it helps to first know what current state law already says. So let's actually try to read this without the bold. Okay. A person commits the crime of animal abuse in the second degree if, except as otherwise authorized by law, the person intentionally, knowingly, or recklessly causes physical injury to an animal. Any practice of good animal husbandry is not a violation of this section. And then animal abuse in the second degree is a class B misdemeanor currently. Okay, so really important part. Intentionally, knowingly, or recklessly causing physical injury to an animal. That is animal abuse in the second degree. If it were serious physical injury to an animal or resulted in the death of that animal, then it would be animal abuse in the first degree. So sections 3 and 4 are both animal abuse. One is the second degree, one is the first. They differ in terms of the severity of the injury. Okay. Now, you'll notice two things that we remove, right? One is this exemption for any practice of good animal husbandry. This exception is written into the state law in multiple places, okay? And we wanted to remove it from multiple places because we do not think that good animal husbandry, which is husbandry practices that are common in the industry, that are defined by the industry itself, are not a reason, are not justifiable to warrant intentionally, knowingly, and recklessly causing physical injury to an animal, right? We want to move society in a direction where we have alternative strategies for meeting our needs, right? Whatever those needs might be, that don't involve intentional, knowing, or reckless injury to an animal. Okay. So we remove that. We also remove this reference, otherwise authorized by law, which is specifically pertaining to a list of exceptions that are laid out later on in state law. And I'd actually like to jump to that next. But right before we do, we did add in bold up here, except as necessary to defend against the threat of immediate harm to oneself, to other humans, or to other animals. Okay. We, similar to how good animal husbandry is actually currently in state law in multiple places, we added in multiple places this exception for self-defense to make it very clear that if you were intentionally, knowingly, or recklessly causing physical injury to an animal, defending yourself or others, that would not be considered animal abuse, right? But what's really important is this animal husbandry exception is not the only exception, right? So let's actually jump now from section 3 and 4 all the way down to section, I believe, 9. Perfect. Section 9, which kind of just starts at the top here, but goes on to the next page. Okay. It says that except as provided in subsection 2, unless gross negligence can be shown, the provisions of ORS 167.315, which is animal abuse in the second degree, which we just talked about, all the way to sexual assault of an animal, do not apply to, and then lists the following conditions. So currently in state law, the following conditions are exceptions to our animal cruelty statutes. The treatment of livestock being transported by owner or common carrier. Animals involved in rodeos or similar exhibitions. Commercially grown poultry. Animals subject to good animal husbandry practices. The killing of livestock. Animals subject to good veterinary practices. Lawful fishing, hunting, and trapping activities. Wildlife management practices under color of law. Lawful scientific or agricultural research or teaching. Reasonable activities undertaken in connection with the control of vermin or pests, and reasonable handling and training techniques. Those are all current exceptions to our animal cruelty statutes. And you'll notice that all but one of them would be removed if this initiative were to pass. Okay? Because again, we think that this is unnecessary to meet our needs. Okay, we are quite confident that we can find alternative strategies to meet whatever needs of ours we have without intentionally, knowingly, and recklessly causing harm to animals. Okay. And by removing these exceptions, okay, any of these activities, if they involve injury of an animal, intentional injury of an animal, they would become classified as animal abuse, or in some cases, animal neglect, or in other cases, animal sexual assault. Okay. We do add in the self-defense exception again here, okay? And we leave in the exception for veterinary practices. This would protect things like spaying, neutering, and vet-administered euthanasia. Okay. In theory, that specific practice is done solely for the benefit of the animal, or at least primarily for the benefit of the animal, right? That is why we decided to leave that in there. Whereas all other exceptions are really for our own benefit, not for the benefit primarily of the animal, and obviously, right, slaughtering them is not benefiting these animals. So we remove these exceptions, okay, and simply allow our current animal cruelty statutes to take effect for all animals statewide. This is why, when talking to the public, we will often say, this initiative removes exceptions from our current animal cruelty laws that right now keep our companion animals safe. We would extend those same protections that they already have to animals on farms, research labs, rodeos, and out in the wild. Those are sort of the big four categories of animals that this would help protect. You'll notice companion animals aren't exempt from our animal cruelty laws, right? There's none of these conditions are specific to our companions except perhaps handling and training techniques. So this would actually help companions a little bit more because there are potentially some techniques that would be no longer allowed. But by and large, these help animals that are aside from our companion animals. Okay, so hopefully that gives sort of a basic understanding of what this initiative does. By far, that is the biggest impact, but there's still more to unpack here. So let's jump back up to, we covered animal abuse. I want to get back to the changes that we have to the misdemeanors. I'll come back to that in a little bit. I want to instead go to neglect. So section 5, okay, a person commits the crime of animal neglect in the second degree if the person intentionally, knowingly, recklessly, or with criminal negligence fails to provide minimum care for an animal, tethers a domestic animal currently, okay, and it results in injury. The big ones. There's also neglect in the first degree, similar to the pattern we see with abuse. First degree is just a more severe physical injury or death. Right? One of the things we remove here is the word domestic. Okay, and domestic has a specific definition. It's not actually just domesticated in that particular sense. So if we go back to section 2, this has a bunch of definitions that apply to our animal cruelty statutes. And a domestic animal means an animal other than livestock or equines, horses, that is owned or possessed by a person. So specifically, really, this is our companion animals, right? So if you are tethering a companion animal and it results in their injury, you can be considered having violated our animal neglect statutes, right? But that does not help the farmed animals. It does not help animals that are in rodeos and exhibitions. That does not help animals that are in transport, right? Again, those are currently exempt from this definition. So we first remove that reference, right? Just an animal in the person's custody. If you are tethering them and it results in injury, that is considered neglect. Okay. There are some other definitions in section 2 that apply specifically to the animal neglect statute, which is why I wanted to wait to come back to this. So actually going back to section 5 real quick, you'll notice the first part, A here, fails to provide minimum care for an animal in such person's custody or control. Well, what is minimum care? That is defined, right? We go back to section 2. There's a couple important definitions. One of them, minimum care, means sufficient care to preserve the health and well-being of an animal, um, including food of sufficient quantity and quality, open or adequate access to potable water. For a domestic animal, other than a dog engaged in herding or protecting livestock, access to adequate shelter. Okay. Um, Veterinary care. For a domestic animal, continuous access to an area with adequate space for exercise, with air temperature suitable for the animal, kept reasonably clean. Okay. So again, we remove references to for a domestic animal. So all animals that are in our care must have continuous access to an area with adequate space for exercise that's for the health of the animal, with air temperature that's suitable for the animal. All animals, not just domestic animals that are in our care, should have access to adequate shelter. And we also even remove further instances of domestic that are incorporated into this definition itself of what adequate shelter even is and what adequate bedding even is. So right now, adequate bedding is currently defined as bedding of sufficient quality and quantity to permit a domestic animal to remain dry and reasonably clean, right? So by definition, you can't have inadequate bedding for a farmed animal. That just doesn't, by definition, it only applies to keeping a domestic animal dry and reasonably clean, right? We are changing this so that all animals within our custody or control must have adequate bedding, adequate shelter, adequate space for exercise, etc. Obviously, this would have a big impact on farmed animals, animals in rodeos and exhibitions, animals in labs, right? They are not currently given these things by and large. And so that would be then considered animal neglect. We reiterate this a lot, but anything that we can't currently do to one of our companion animals, we wouldn't be able to do to those animals on farms, research labs, rodeos, and out in the wild. We're extending the same protections that our dogs and cats have to all animals statewide. Okay? This is quite literally what it is doing. And we really want people to think about, why are these exemptions built in the first place, right? Why are we treating some animals differently than others? Okay, there's a lot of intention behind why we are going about it in this particular way. There are some other things that we do in Section 2 that have an impact, so let's go through them now, even though they don't impact neglect specifically like those others do. We remove good animal husbandry altogether. It's no longer an exception, so we are just removing it. But it is essentially includes things currently, like the dehorning of cattle, docking of horses, castration and neutering of livestock, according to accepted practices of veterinary medicine or animal husbandry. And it includes, but is not limited to, those practices. Under this section that we already talked about briefly, for minimum care, right, that defined things like needing veterinary access, continuous access to an area with adequate space, currently, minimum care also includes something specific for a livestock animal that cannot walk or stand without assistance. And this says either humane euthanasia or the provision of immediate and ongoing care to restore the animal to an ambulatory state. Right. What we have done is removed this section here. Okay. And we have done that for a couple reasons. Right now, it is common practice for farmers, if an animal is injured, okay, to kill them on the farm. I've even heard a farmer, someone refer to this as dispatching, right? Of course, we would never dispatch a companion animal, okay? When a companion animal gets sick, we take them to a vet, and potentially, right, the vet may engage in euthanasia. That practice is still protected here. What this prohibits is farmers themselves killing animals that they deem to not be able to either go to slaughter anymore, to be just sick and injured and an inconvenience. Typically, this type of euthanasia, quote unquote euthanasia, I would call it, is more about the convenience of the human individual rather than the animal individual. So again, we leave in the exception for veterinary care and veterinary practices. So if there is an animal of any species that is very sick, very injured, and the vet genuinely believes that it would be an alleviation of suffering to help end their life, the veterinarian can still help and make that decision. Okay. But we are not going to put that decision in the hands of just anyone who might be motivated to make that call based off of convenience rather than the animal's best care in mind. Okay. So the same process that someone would use for their companion, they can still use for an animal of any other species. Okay. Lastly, tethering currently is defined to be restraining a domestic animal. A lot of redundancy in state law, but we had to go through and we removed that reference. So tethering, tying up any animal, and if that results in injury, that would be neglect. So now we can go down to section 7. Actually, I want to come back to section 7 because I want to talk about sexual assault first, which is section 8. Okay, so we've talked about abuse, we've talked about neglect, and now let's talk about animal sexual assault. Right now, ignoring the bold, a person commits the crime of sexual assault of an animal if the person touches or contacts or causes an object or another person to touch or contact the mouth, anus, or sex organs of an animal or animal carcass for the purpose of arousing or gratifying the sexual desire of a person. Okay, that is what it currently says. When I first read this was actually the first animal cruelty statute that I read when initially looking into our animal cruelty statutes. And it struck me as quite odd that it was only a case of sexual assault if essentially the perpetrator was receiving sexual gratification from the act. We would never apply this standard in any other situation, right? So we did two things to this. We first made it clear that if there is an intention to arouse or gratify the sexual desire of either the human or the non-human animal, okay, that would count as sexual assault. Also, if it is for the express purpose of impregnating or masturbating the animal, that is also considered sexual assault. So what this would do, right, largely, is ban breeding practices that involve a person or an object coming into contact with the mouth, anus, or sex organs of an animal or animal carcass. Okay. Rather than have this be really about the sin of bestiality, this is now a legal statute protecting the bodily autonomy of animals, which I think is much more in line with sort of a needs-based ideology, right? If laws should serve needs, and we think that this is now in service of actual needs. Okay, so we talked about the main exceptions that were removed. We talked about abuse, neglect, and sexual assault. Now let's go back and first, what would actually be most helpful? Yeah, let's go to section 7 because we skipped over section 7. So our campaign, most people on our campaign, if not all of them, are critical of our current system of retributive justice, right? We are much bigger fans of restorative justice. We are not we see a lot of evidence that our current system of incarceration is not helping, that it often leads to higher rates of recidivism, that it usually leads to worse outcomes rather than better, right? So we wanted to figure out a way to still use, right, our criminal statutes, but create a way of establishing a restorative justice approach to protecting animals. And this is how we did that. Let's first look at this section 7 as it currently stands. So again, I know it's hard to ignore the bold while it's there, especially it being in bold, but right now in current state law, this is already a state law, in addition to any other penalty imposed by law, a person convicted of violating one of our animal cruelty statutes, this just lists them out, may not possess any animal currently of the same genus, which is like one level above species, against which the crime was committed, or any domestic animal, for a period of 5 years following entry of the conviction. So, right, and this second paragraph is actually the same thing, but it lists the first degree penalties. So this first paragraph is about all the second degree, for the most part, one first degree statutes, and these are first degree, some sexual assault, and it has for a period of 15 years. Okay, so 5 years, 15 years. What this is saying, to kind of reiterate, in addition to any penalty imposed by law, someone convicted of a crime of animal cruelty may not possess an animal of the same genus for either 5 or 15 years, depending on the severity of the conviction. Okay, this is already in state law. What we did was we first, and probably most importantly, changed addition to in lieu of. Okay, in lieu of, meaning as an alternative to any other penalty imposed by law, a person who's convicted of a crime of animal cruelty could essentially instead, by determination of a judge or by potentially self-selection, right, not possess an animal, not of the same genus, but just an animal. So we got rid of this reference to same genus. So if you convict a crime, right now, it's like if you convict a crime against dogs, then you would be prohibited from owning other dogs, right? If you're convicted of a crime, and actually that's really the most common cases because most animals are exempt. So there's actually exceptions in here that we remove that talk about if the person's conviction is only involving livestock, doesn't apply. If it's there are the same exceptions that already we talked about, right? So, but in theory, whatever that genus is of an animal. In this case, what we changed it to, if you are convicted of abusing an animal of any species, then you will be prohibited from owning an animal of any species for a period of 5 years or 15 years, depending on the severity. And we added, in addition to that animal ownership prohibition, they would then complete either 100 hours or 300 hours of supervised community service at an animal care facility. Okay, and we specify what type of animal care facility that this can community service can happen. Specifically, a farmed animal sanctuary, a wildlife rehabilitation care provider, or a humane society or animal shelter. And we did put in that one of these facilities should be selected depending on the genus of the animal against whom the crime was committed. Okay. This is important in the sense that if you are convicted of abusing a farmed animal, well, then it makes sense to have you be engaged in community service at a farmed animal sanctuary. Supervised, so it's not unsupervised service. And the reason we did this, the intention behind it, there is a lot of research showing that when we engage with others who we currently have a lot of dislike towards or desire of violence towards, or whatever the case might be, we have a lack of empathy, engaging with those others helps build empathy. And certainly taking care of those others builds even more empathy, right? The idea is when we start engaging in behaviors that are different than our current values or thoughts, they tend to come into alignment with each other. So we're hoping that some supervised care, you'll get to take care of similar animals to the ones that you previously have not taken care of in this case, then hopefully that will build that empathy. If it was an instance of abuse to an elk, then you would have a supervised service at a wildlife rehabilitation care provider. If it was abuse to a companion animal, then it would be a humane society who largely take care of companion animals. So we wanted that to be sort of appropriate for the conditions. We do have in here that if there is a time period for the supervised service, but it can be extended. So we usually give, I think it's 3 months by default, 3 months for the 100 hours and 9 months for the 300 hours, but the court may issue a one-time extension as long as it seems like they are in good faith working towards this. And if they end up violating the animal ownership prohibition, okay, there would extend that prohibition. It would be a separate misdemeanor, which again these are already in state law. The main thing we're changing is that this can now be used in lieu of another criminal penalty. So maybe to reiterate that, you would not face those misdemeanor charges if instead you would agree to an animal ownership prohibition and the community service. Okay. This is because we think that this is a more restorative approach to this process. Okay. The other thing that we did that has to do with sort of our current view on incarceration is we lowered the criminal penalties throughout the animal cruelty statutes. Okay. Our goal here is not to throw people in jail. Okay, we have no interest in that. One thing that's important to keep in mind of the goal of our campaign, right? We want to move towards a world that no longer uses animals for food, clothing, and entertainment. We think that forcing the vote on this issue is going to make it more likely to occur in our lifetimes. We also think that by the time 50% of people vote for something like this, the world will already start to look pretty different. So there won't be, as rampant animal agriculture as there currently is now. Also, if this were to pass, it prohibits the state, and this is probably most important, from authorizing, giving out licenses for slaughterhouses or different animal facility, current facilities that intentionally injure animals. It would prohibit the state from giving out hunting licenses. It would prohibit at a state level, at a systemic level, this cruelty to happen. That is our big goal, right? We are not interested in going after individuals, okay? We are trying to change the system and society in place. And maybe as a demonstration of that we're not interested in individual incarceration, that is sort of part of the intention behind why we lowered these misdemeanors. So in Oregon, there's Class A, Class B, Class C misdemeanor. A is the harshest, and then harsher than Class A misdemeanor is a felony, right? And so we changed, for instance, Class B misdemeanors to Class C. We changed Class A to Class B. Okay. We also changed felonies, C felonies. It sort of restarts. So then a Class A felony is the worst. B felony is a little bit less. C felony is a little bit less, but it's all a bit more than a misdemeanor. We changed C felonies to A misdemeanors. Okay. We just lowered it basically one step. Okay. The only exception to that is we increased from a C misdemeanor to an A misdemeanor the violation for if you violate the animal ownership prohibition. And we think that one is the most serious because if you agree to not own animals after already being convicted, and then you go ahead and possess animals in violation of that, we think that that's a serious, the biggest predictor of most behaviors, not even just violent behaviors, but most behaviors is prior engagement in that behavior. And so we do want to make it, very clear that we take that. If someone is not willing to engage in the restorative process, then we believe it's more justified to use force to prohibit them from possessing animals in the future. But throughout, otherwise, we lowered by 1 degree our penalties. Okay. So now we've talked about abuse, neglect, sexual assault. To wrap up, we talked about, or to at least recap, talked about the major exceptions to animal cruelty laws. We talked about the alternative to incarceration. The last big thing that was actually added to this initiative as opposed to prior iterations is the humane transition section. So this is now, from here on, section 10 down, we're no longer amending animal cruelty statutes. We're adding in a fund to help with a just transition. Okay, so the Humane Transition Fund is established in the state treasury, separate and distinct from the general fund. It shall be credited in a couple different ways. Okay, so money can be transferred from the Legislative Assembly. And we include in here that the Legislative Assembly shall appropriate or transfer to the fund an amount sufficient to fully fund the grants program required by Section 12. And Section 12 talks about what the grants can be used for. Most importantly, at least in terms of where some of this funding comes from, to the greatest extent allowable by law, all subsidies distributed in Oregon to be used for a purpose that would no longer be allowable by the implementation of this act shall instead be credited to the Humane Transition Fund. So any money going towards activities that currently intentionally, knowingly, or recklessly injure animals, that money should then instead go to this transition fund. Okay. The transition fund can be used for the following activities. And the Transitional Oversight Council, which we'll talk about in a second, provides grants for any of these purposes. Okay, or I guess actually, sorry, these are who the money can go to first. The money can go to existing agencies or organizations, emerging or newly formed organizations, private individuals. Okay, and it can be used for the following purposes only: to help with food assistance. Okay, either directly, food and cash benefits, or indirectly, funds for opening private or state-run grocery stores. To replace lost income due to the implementation of this act until the individual has completed a job retraining program and acquired new employment. To cover all the costs of operating a job retraining program. To cover the cost of animal care for individuals or organizations supporting animals who could no longer be killed or harmed due to the implementation of this act. To assist in conservation and rewilding efforts. And any other purpose that is unanimously agreed upon by all members of the Transitional Oversight Council. Okay. So quite a few things that this can be used for, obviously all in the service of meeting our needs, both the needs of the individuals now, the humans, and the animal individuals, of course, trying to make sure that they are taken care of as well. The Transitional Oversight Council. So we establish a council that needs to have, I think it's at least, a quorum consists of 7 members, but it can have quite more than that, okay? Because our goal is to have at least one member from each of the following categories. And we listed quite a few because we really do want everyone who is impacted by this to help in the transition. Okay. People know best what alternative strategies can be used to meet their needs. Okay. Our goal is to keep, sort of recentering. Yes, we want to protect the needs of animals. Given that we are going to move away from intentionally, knowingly, and recklessly injuring them, now what other strategies can we come up with together to meet your needs, right? So we need everyone at the table. So a representative from the Oregon Department of Agriculture, representative from the Oregon Department of Fish and Wildlife, representative from the Office of Tribal Affairs, a representative of the Oregon Department of Human Services Vocational Rehabilitation Program. This was intentionally, hopefully you kind of see why these people are picked. But if we're going to offer a job retraining program, someone with some experience in that might be helpful. A representative of the Oregon Department of Human Services Self-Sufficiency Program. Representative from each of the 9 tribal governments in Oregon. Representative from the Oregon Farm Bureau. 3 members of communities that would be directly impacted by the implementation of this act. 3 members of communities not directly impacted by the implementation of this act, in theory, some neutral parties, a professional in the field of veterinary medicine, a person who works for a nonprofit farmed animal sanctuary, especially if these animals are going to be taken care of for a longer period of time, that might be useful. At least 2 people who have a documented history of advocating on behalf of animals who would be protected from harm by the implementation of this act. We do want some of us on here as well, so to speak. I mean, we're all in us, but some people with experience really centering animals we think is valuable. One of the chief petitioners of this act or a person appointed on their behalf. Okay, so again, at least one person from each of these categories. Terms of office for the council shall be 4 years. Vacancies shall be appointed. To the extent permissible by law, services for the council can be compensated from their employer if that's possible, or potentially from the state if that is something that we're able to provide. Okay, so in theory, right, people are coming together who are impacted by this initiative to help figure out how to transition away from killing animals. We do care about the transition, but again, we just want to center those animals, those needs, and figure out alternative strategies that do not involve intentionally, knowingly, or recklessly causing them harm. That is language, if you are a petitioner on this campaign, that we keep bringing back. And when you talk with people on the street, it's very common, and we encourage you to help identify those needs that they are speaking about. Okay, empathize with those needs, bring up the needs of the animals, and talk about how we can try to meet both of those needs. Okay, we are very confident as a campaign that there are strategies to meet everyone's needs. In fact, our needs are not the conflict. It's the strategies that we're choosing that are in conflict. Okay. Last two sections, miscellaneous. So this act shall become effective according to the Oregon Constitution and operative 30 days after the election, which the act is approved. 30 days is just the legally required amount of transition time. That's the smallest amount of time that we're allowed to put. I think that if we believe that what is happening to animals is as serious as we claim it is most consistent to ask for the immediate liberation of animals now. I think that delaying it is not consistent. That is why we picked this, right? We also, again, I will reiterate, I know I mentioned this earlier, by the time that something like this is ready to pass, by the time 50% of Oregonians are ready to move away from killing animals, I think the world will already look quite different than it does now. So this might not be as, it's hard to speculate exactly what the transition would look like. But again, we want the immediate liberation of animals. Okay. And then severability, just a common legal clause. If anything in this act is deemed invalid, does not invalidate the rest of the act. So there you have it. 10 pages of Initiative Petition 28. I hope that was informative. And of course, if you have any questions, you can reach out to the campaign. Our email, for those of you who are not in the campaign, if you would like to email us, it is team@yesonip28.org. We also have, obviously, our website, yesonip28.org. And if you go to the About page, there is sort of a common questions section. Definitely encourage both people on the campaign and not to read through that, because it does also highlight a lot of the language that we like to use when talking to people. So yeah, again, hopefully you found this informative. I appreciate taking the time to watch and listen to it. And hope the rest of the day goes well.